the vast majority of cases are not going to trial. That being said, a ton of cases go into litigation. So what's the difference? So from the time of the incident until a lawsuit is filed is considered pre-suit, like before a lawsuit's filed. That's what it's classified as. Once a lawsuit's filed, it's in litigation. It may be in litigation for years. And then at the end of the litigation, it culminates in a trial. Okay, so the trial is pretty much the last stop on this train you're on. But a ton of cases go into litigation as opposed to settling without litigation. So why is that? First of all, you got to look at the fee contracts. I think this drives a lot of people. When you sign up with an attorney or when you engage an attorney in a personal injury case, fees vary. The industry standard is that if a case gets settled pre-suit, like before a lawsuit's filed, it costs a third. And then if you have to actually file a lawsuit, it goes to 40%. That's roughly a 7% increase. That's one financial motivation. Let's just be honest. We're all human here. There are times I see cases and I scratch in my head like, why on earth would this person file this lawsuit? Why would they do it? And the only thing that I can come up with at that point in time is, somebody's getting that extra 7%. I hate to say it like that, but those things happen. We're human. We all have our motivations. But cases, more often than not, don't need to go into litigation. There are cases that need litigation and cases that don't, that have nothing to do with the value of those cases. If you put together a properly supported demand and send it to the insurance company, and the key word there, the key phrase is properly supported, that's realistic, more often than not, you're going to settle the case. It's better for everybody. Sometimes, not always, but it's better for everybody because the client doesn't have to wait years to get the money they need, to get the medical care they need. The insurance company doesn't have to hold the case on its books for years. It's better for everybody to resolve things quickly, if possible, if it's appropriate. And sometimes it's not appropriate. But you want to make sure that you send a supported demand. So what is a supported demand? At its very basic, what you're going to see is a copy of some sort of incident report. It could be a police report saying that this crime happened here and this person was hurt. It could be a traffic crash report. The police give you, says, hey, there's a motor vehicle accident. This is what it was. It could be a report written by a business where something happened, where they document, hey, these are the events that unfolded. But there needs to be some sort of report. There also needs to be photographs and videos, if at all possible. These are things that need to be documented from the get-go. So why not have them early on and include them in a demand? Photographs of the scene where the crime happened, photographs of the vehicles involved, photographs of the injuries. If appropriate, maybe a video showing the limitations that a person has. Things to document this stuff and make it actually tangible. The next thing a supported demand will need to have, of course, are your medical bills and records to date. Those are pretty standard. In our demands, we often take it a step further. What we'll do is we'll go talk to the doctors and say, hey, doc, Miss Smith over here, we represent her. These are the records that you've produced. This is the treatment that you've given her. Would you mind giving us a medical narrative? Medical narrative is simply a tool by which we can get that doctor's testimony into evidence cheaply. Doctors, they're businessmen. They're not going to take 2 or 3 hours out of their day and come sit down with me in my office and let me videotape them for free. Doctors are going to charge thousands of dollars to come do that. But with a medical narrative, we can write it, give it to the doctor, give the doctor an opportunity to make any changes the doctor wants to make, have them sign it, And there we go. We've got, a page, 2, 3 pages worth of their testimony that's admissible that would be admissible in court and evidence because of some evidentiary rules. But we're not waiting until the day of trial or 6 months before trial to do that. We're doing it up front to show the insurance company that we are actually prepared to go that route if necessary. So we'll put together medical narratives. If a case warrants it, we might have an accident reconstructionist go out or some other sort of expert to do an analysis of how this all happened. It's funny, I tell people all the time, like you've got what you remember, and everybody's kind of, to varying degrees, they can recollect what happened a week ago, but you pull them back 2 years after the fact, their recollection is not going to be that good. They're going to remember what they want to, what was important to them, but the details they're going to lose. When we send these experts out, they'll take into consideration the testimony. I mean, they have to consider everything, but they're really basing their analysis on measurements and time. And it's science, people. It's, there's science behind it that you just can't deny. In addition to that, if the person needs follow-on medical care, if, Miss Smith has a condition that's going to require treatment, surgery, whatever it may be in the future, we'll go ahead and get an estimate done. We'll go engage the services of a hospitalist to say, hey, this is the treatment that Miss Smith is going to need over the next 20, 30 years, whatever it may be. This is what we project the cost to be. We'll include those things in our demand. Sending a well-supported demand that you've got everything done that you could possibly do at that point in time tells the insurance company that this is being taken seriously. We take it seriously. And it gives them a basis to decide what their value is. You've got to give them information in order to get a number back. You can't just call or just send a letter and say, hey, Miss Smith was in an accident yesterday. She went to the emergency room. Your policy limits are $100,000. We want them by tomorrow. The insurance company can't do anything with that. You have to give them information to allow them to make a reasoned decision. Again, insurance companies are not. I mean, I'm not going to get down on them that much because they're in the business of settling claims, but they're in the business of paying reasonable amounts for claims. If you give them the information they need to make a decision, they'll do it. Just make sure that your attorney is sending a supported demand.